Can a trustee sell a house in a trust after death? A successor trustee can sell a house in a trust after death without probate when the house is titled in the trust and the trust document gives the trustee sale authority. This video is mainly about a home held in a revocable living trust after the grantor dies. Other trust types can have different rules, so confirm the trust terms with an estate attorney. If the house was never funded into the trust, probate or a court petition may still be needed. I'm Rhett Fruitman, co-founder of Inherited Property Match. My background includes Citi Private Bank and CBRE, and I help families navigate inherited property sales across the country. This is general information, not tax, legal, financial, or real estate advice. Before you sell inherited property, speak with a CPA, and when probate or trust administration is involved, an estate or probate attorney. If you are the successor trustee, start with 3 things: confirm your authority, confirm the title, and protect the property. What should a trustee confirm before listing the home? Before listing the home, the trustee should confirm that the deed shows the trust as owner, the trust gives sale authority, and every required trustee can sign. Start with the deed. If it still names the grantor individually, the trustee may not be able to sell as trustee. Ask the title company or estate attorney to review title before you list. If there are co-trustees, confirm whether one trustee, a majority, or all trustees must approve and sign. Then gather certified death certificates and a certificate of trust, trust certification, abstract of trust, or trustee affidavit if the title company requires one. What happens if the house was never put into the trust? The trustee may need probate, a small estate procedure, or a court petition. If the owner lived in one state and the house is in another, ask whether ancillary probate is needed in the property state. How long does a trust sale usually take? A straightforward trust sale commonly takes 2 to 4 months from authority review to closing, but title defects, disputes, property condition, or state-specific trust rules can extend the timeline. The early weeks are administrative. Secure the property, check insurance, confirm a trust bank account, and ask the CPA whether the trust needs an EIN. Then confirm utilities, access, occupancy, mortgage status, HOA dues, and property tax bills. Can a trust sale close faster than probate? Yes, because a properly authorized trustee usually does not wait for letters testamentary, letters of administration, or court confirmation. But speed still depends on clean title, property preparation, buyer financing, and beneficiary issues. How does trust sale authority differ from probate? A trust sale avoids probate court involvement when the trust already owns the house and gives the trustee authority to sell. In probate, the court appoints an executor or administrator before the property can move through the estate process. In a trust sale, the successor trustee can often work directly with the broker, title company, CPA, and attorney. A trust sale is also more private on the administration side because there may not be a full probate case, but deeds, transfer records, and any trust dispute or court petition may still become public. Does a trust sale always avoid probate? No. If the house was not funded into the trust, a pour-over will does not automatically let the trustee sell. A court process may still be required to clear title. What fiduciary duties does the trustee have? A trustee must manage and sell trust property for the beneficiary's interests, not the trustee's personal interests. That means loyalty, impartiality, prudent management, and good records. Document pricing, repair decisions, as-is decisions, broker selection, offers, expenses, and final proceeds. Can beneficiaries stop a trustee from selling a house in a trust? Beneficiaries generally cannot veto a properly authorized trustee sale just because they disagree, but they can challenge the trustee if the sale violates the trust, involves self-dealing, or breaches fiduciary duties. Tell beneficiaries the sale plan, how value will be supported, and when they should expect accounting and distributions. The trustee should also confirm required notices, creditor procedures, and distribution timing with counsel. What tax issues matter when selling trust property? The main tax issues in a trust home sale are stepped-up basis, capital gains, trust income reporting, possible Form 1041 filing, and state or local property tax reassessment. For a typical revocable living trust where the home is included in the deceased owner's estate, the property generally receives a stepped-up basis to fair market value at death. That can reduce or eliminate capital gains if the sale happens soon after death. Does trust property get a stepped-up basis? For a typical revocable living trust, yes, but other trust types can be different. Get a date of death appraisal and have a CPA confirm how the basis applies. If the trust earns income or realizes gain, the CPA may also need to address Form 1041. Property tax reassessment is separate from federal income tax. In California, for example, Proposition 19 can affect inherited property reassessment after a transfer. Confirm local rules before assuming the annual property tax bill will stay the same. How should a trustee prepare the property for sale? Before listing, the trustee should secure the home, confirm insurance, identify debts and occupants, and decide whether to sell as is or make repairs. If the house will be vacant, tell the insurer right away. Standard homeowner policies can have vacancy limits, so do not assume coverage continues unchanged. Then check for a mortgage, HELOC, reverse mortgage, liens, HOA dues, unpaid taxes, tenants, or a beneficiary living in the home. Those issues affect timing, pricing, access, and closing requirements. Can a trustee sell a trust house as is? Yes, if the trust and state law allow it, and the trustee can show the decision is prudent for the beneficiaries. Document the reason and disclose known property issues as required. What should trustees do before the sale closes? Before closing, the trustee should make sure the title company has the right documents, sign in a fiduciary capacity, and send proceeds to the trust account instead of a personal account. Avoid commingling trust funds with personal money. After closing, keep reserves for taxes, debts, claims, expenses, and final accounting before distributing money to beneficiaries. Can a trustee sell the house to a beneficiary? Sometimes, but that situation needs extra care. Get legal guidance, support the price with an appraisal or market analysis, disclose the conflict, and document consent or court guidance if required. If you inherited property and need help finding a broker who understands estate-related sales, inherited property. Match can connect you with a vetted broker experienced with inherited property. The match is free,